How y'all doing in America? Hopefully, Trump is making America great again. Um, Not sure if anybody can hear me. Let me see. I'm just going today. I'm gonna read what I had filed November 27th, 2024. It's in reference to my lawsuit. I filed a complaint, Federal Rule 59E, motion for reconsidered of an oral argument uh, um, in regards to a manifest error of law, a due process challenge of exhaustion doctrine on probable cause for arrest, challenged and conducted as prescribed by law, Docket 146. But I'm just sitting here trying to figure out if I got sound. Look like I got sound. Yeah. Okay. So what I'm adding to my case. I'm not sure if y'all remember about the Chevron doctrine that just got overturned in June 2024. It's in reference to our all three-letter agencies, in accordance to the law, how they define the law and what they say. So Loper, Bright Enterprise, ET practitioners, Gina Raymond, Secretary of Commerce. Justice Douglas explained as a necessary consequences of our system, in which each judge takes an oath, both personal and binding, to discern the law's meaning for himself and apply it faithfully in the causes that come before him. Justice Douglas reflected, as new colleagues would remember, that is a Constitution which he swore to support and defend, not the gloss which his predecessors may put on it. And so he would come and to formulate his own views, rejecting some earlier ones as false or embracing others. Jackson's decisions law and stare decisions. It is not for us to pick and choose passage when we happen to like and demand total obedience to them, and perpetuity that would turn stare decisions from a doctrine of military into a tool for judicial opportunists. That's Brown 596 U.S. At 141. Case law is a collection of judicial decisions that establish legal principles and proceedings for interpretation of the law. Case law is based on judicial decisions rather than law based on the Constitution statutes. Case law based on judicial decisions rather than law based on the constitutional statutes and regulations. If it shows that the defendants' actions were improper and violent, the existing clearly established constitutional law. At step one, a judge must defer an executive officials' interpretations when the statutes at hand is ambiguous. Step two, a judge must interpret the ambiguous statute as reasonable. Under the Chevron deference undermines other aspects of our settled law. Two, in this country, we often boast that the Constitution promise of due process of law, see Amendments 5 and 14, means that no man can be judged in his own case. William versus Pennsylvania, 579 U.S. 1. Calder versus Bull, That principle, of course, has deeper roots, tracing far back into common law, where it is known by the Latin maxim "Nemo edux in causu." C1E Cope Institutes of Laws, England. Chevron deference undermines all that. It precludes courts from exercising the judicial power vested in them by Article 3 to say what the law is. It forces judges to abandon the best reading of the law in favor of views of those presently holding the reins of the executive branch. It requires judges to change, and change again their interpretations of the law as in when the government demands, and that transfer of power has exactly that sort of consequences one might expect. Rather than insult adjudications from power and politics, uh, to ensure a fair hearing without respect to persons, as a federal judicial oath demands, 28 USC 453, Chevron deference requires courts to place a finger on the scales of justice in favor of the most powerful of litigants, the federal government. Buffington 598 U.S. at. Along the way, Chevron deference guarantees systematic bias in favor of whichever political party currently holds the levers and executive power. The Federalists, all of this serve to ensure the same thing: a fair trial, and a fair tribunal. And Merchants 349 U.S. at 133, one in which impartial judges, not those currently wielding power to political branches, would say what the law is. In cases coming to court, Marbury judges have neither force nor will they merely, but will merely judgment, and the obligation to exercise that judgment independently. The Federalist, number 78 at 465. No matter how disagreeable that duty may be, this court has said a judge is not at liberty to surrender or waive it. United States versus Dickens, 15 Pet 141. This duty of an independent judgment is perhaps the defining characteristics of an Article 3 judges. Stern versus Marshall, 2011. The courts must identify the specific constitutional right alleged infringed by the constitutional right alleged infringed by the challenged applicable of force, and then judge the claiming by reference to the specific constitutional standard which governs that right. Claims that law enforcement officials have used excessive force in the course of an arrest, investigated stop, or other seizures of a free citizen are most properly characterized as invoked in the protections of the Fourth Amendment, which guarantees citizens the right to be secure in their persons against unreasonable seizures and must be judged by reasonable standard. Chevron deference is inconsistent with the directions Congress gave us in APA. It represents a grave anomaly when viewed against the sweep of historical judicial practice. The decision undermines core rule of law values. Core rule of law values range from the promise of a fair notice to a promise of a fair hearing. The Fourth Amendment of reasonableness inquiring is whether the officer's actions were objectively reasonable in light of the facts and the circumstances confronting them. In regards to, I'm not sure if a lot of people understand what I'm talking about in regards to the seizures. The Fourth Amendment, it just guarantees you the right to be free of anything. If you ain't done nothing wrong, you don't need to be detained or seized or what have you. But with this Chevron deference, what the court's been doing is that everybody that's been done wrong, like me and thousands of other people's, and they took it upon themselves to try to file a court lawsuit against the whole city. They always kicked it out because of you can't state a claim, you can't do this or do that. But because they violated every rule and law that they passed. I mean, this is their laws. It's not mine. The Chevron deference that was overturned. It's gonna. I'm hoping it's gonna help me and pursuing my goal is to make everybody equal. You know. So yeah. So yeah, I'm gonna continue reading. So which Fourth Amendment, which guarantees the right to citizens be secured in their persons against unreasonable seizures and must be judged by reasonable standard. The Chevron deference is inconsistent with the directions Congress gave us in the APA. It represents a gravely anomaly when viewed against the sweeping historical judicial practice. The decision undermines core rule of law values ranging from the promise of fair notice to a promise of fair hearing. The Fourth Amendment of reasonableness inquiry is whether the officer's actions were objectively reasonable in the light of the facts and the circumstances confronting them. Without regard to their underlying intent, motivation, the reasonableness of particular use of force must be judged from the perspective of a reasonableness officer on the scene, and its calculus must embody an allowance for the fact that police officers are often forced to make a split-second decision about the amount of force necessary in particular situation. To balance the necessity of the use of force against the arrestee's constitutional right, a court must evaluate several factors, including the severity of the crime at issue, whether the suspect posed an immediate threat to the safety of officers or others, or whether he is actively resisting arrest or attempting to evade arrest by flight. Graham, that's Graham versus O'Connor's, 490 U.S. Um, and stating that in determine if force was reasonable, courts must examine the need for the application of force, the relationship between the need and the amount of force used, and the extent of the injury inflicted. As the court also recently explained in Lee, Graham dictates unambiguously that the force used by police officers in carrying out an arrest must be reasonably proportionate to the need of that force, which is measured by the severity of the crime, the danger to the officer, and the risk of flight. The power of the executive officer over a person's liberty ends with a lawful arrest. If he never has a discretionary power to detain the person without judiciary authority, the powers to arrest does not confer upon the arresting officer to power to detain a prisoner without purpose. Trespasser albo into nuo, due process of law. The Administration Procedures Act of 1946 APA directs the reviewing court to decide all relevant questions of law and interpret it relevant constitutional and statutory provisions. 5 USC 706. When applying Chevron deference, reviewing courts do not interpret all relevant statutory provisions and decide all relevant questions of law. Instead, judges advocate a large measure of that responsibility in favor of agency officials. Their interpretations are ambiguous. Laws control even those interpretations are at odds with fairest reading of the law an independent reviewing court can muster. Agencies officials too may change their minds about the law's meaning at any time, even when the Congress has not amended the relevant statutory language in any way. That's National Cable and Telecommunications Associations versus Brand X Services, 545. U.S. Not only was a constitution adopted against the backdrop of these understandings, and in light of that alone, they may provide evidence of what the framers meant when they spoke of judicial power. Many other more specific provisions are in the constitutions reflect much of the same distinction between lawmaking and law finding fractions the common law did. The Constitution provides that its terms may be amended only through certain prescribed democratic process. Article 5. It vests power to enact federal legislation exclusively in the people's elected represented in Congress. Meanwhile, the Constitution describes the judicial power as a power to resolve cases and controversies, as well as delegates that authority to life-tenured judges, an assignment that would have made little sense since if judges could usurp lawmaking powers vested in periodically elected representatives, but one that makes perfect sense is what is sought is neutral party. Sorry. To interpret and apply the law without fear or favor in dispute between others, the works of James Wilson Andrews, 1896, see Osborne versus Bank of the United States. An opinion of ex parte Harville, Judge Connor said the imprisonment and jail of a citizen without a warrant, without opportunity for a hearing, or to give bail is a serious matter, and determine whether or not an officer's failure to make an arrested man before a magistrate immediately after his arrest was unnecessary delay. The Supreme Court of Texas stated the accused has a right to be present without delay, but the question of what is a delay must be determined by all facts and circumstances. Necessary some time must elapse between the arrest and the presentation before the magistrate. It is held that a delay from 1.5 hours to 4 hours in failing to take a prisoner before the magistrate arrest without a warrant constitutes false imprisonment. So false imprisonment, that's a big thing. They're doing that to a lot of people around this whole world, and well, at least in America that I know of, and they just direct. It just what do you call it? I just got lost train of thought. But whenever you get false arrest, whenever an officer arrests you, they have to have a reason. The only reason why they arrested me is for resisting. So that's a Fourth Amendment violation. That's a Fifth Amendment. That's every violation that they made in the Constitution. But Williams versus L. Warehouse, plaintiff states it was over 12 hours. It was over 12 hours that I was incarcerated before I was able to post bond, because the judge gave me a bond for $2,500 for resisting arrest. Excuse me. 12 hours prior to bond being set at 2:30 p.m. June 25th, 2022. The due process embraces common law maximus and principles, deprivation of liberty which cannot be done except by due process of law. The ancient existence of due process guaranteed, and that is prominent found not only in the Constitution but in Magna Carta, which proclaims no free man shall be taken or deposed except by legal judgment of his peers or by the law of the land. The common law allowed arrest without a warrant only for known felons and breaches of peace. This is required condition under due process of law. In order to arrest someone, thus it has been said that arrest without a warrant where it is required is not due process of law. The arbitrary of despotic power no man possesses under our system of government. It seems like they do. Muscle versus Commonwealth, 1890. but in truth, the Constitution, the APA, and our long-standing proceedings set those ground rules some time ago. And under them, agencies cannot invoke a judge-made fiction to unsettle our nation's promise to individuals that are entitled to make their arguments about the law's demands on them in a fair hearing, uh, one in which they stand on equal footing with the government before an independent judge. A constitutional violation of Mr. Gonzalez alleges that the defendants violated his Fourth Amendment rights by using excessive force. To prevail in an excessive force claim, plaintiff must show an injury which resulted directly and only from the use of force that was clearly excessive. And three, the excessiveness of which was clearly unreasonable. The unreasonableness of the defendant's conduct depends on the facts and circumstances of each particular case, including the severity of the crime at issue, whether the suspect posed an immediate threat to the safety of officers or others, or whether he is actively resisting or attempting to evade arrest by flight, other known as the Graham factors. One of the Graham factors is that he was released after proving that he did nothing wrong. So Mr. Graham, as Graham versus O'Connor, they pulled him over because they thought he was trying to rob two convenience stores. You would have to look it up. But he was released after. Well, he probably had to go to the hospital because he had a diabetic seizure. Because the officers were detaining him because he was trying to get orange juice out of the convenience store, but the line was too long. So he went to another convenience store. So anyway, whereas I was violently arrested by officers for resisting arrest after demanding to obtain my identification by excessive force, false imprisonment, and due process of law, violate my Fourth Amendment, Fifth Amendment, and 14th A Amendments due process clause, and conspired with each other to try to charge me for terroristic threat, per Captain Longlois, must assess the need for force and relationship between the need and amount of force used. The speed with which the officer resorts to force is also relevant in determining whether the force was excessive to the need. Each of these requires a factual analysis best addressed by the trial fact. This court has several times found that the speed of which an officer resorts to force is relevant in determining whether the force was excessive to the need. See Newman versus Gidra, 703, Fifth Circuit, 2012. Holding that the disputes of fact were material because a reasonable jury could find that the degree of force was used was not justified where the officer engaged in very little, if any, negotiations with the suspect and instead quickly resorted to force. DeVille 567. Determined that a reasonable jury could infer from the plaintiff's deposition's testimony and body camera footage that the defendants, Officer Grantham and McDonald, engaged in very little, if any, negotiations with the plaintiff, and found that instead Officer McDonald quickly resorted to reaching in and unlocking Miss Gonzalez's driver's side door to door lock to unlocking the doors on the plaintiff's side. U.S. versus Nimegs, 9th Circuit, 2020, and Grantham. That particular thing that you can't reach in somebody's vehicle and unlock the door unless they have probable cause or exigent circumstances. And Grantham opened the door, and both officers, McDonald and Grantham, ripping plaintiff out of the automobile. In other words, existing proceedings must have been placed. The statutory or constitutional question confronted by the official beyond debate. The salient question is whether the state of the law at the time of the incident provided fair warning to the defendant that their alleged conduct was unconstitutional. Hope versus Pelzer, 536, 2022 or 2002. Mr. Gonzalez has shown that he sustained a more than D- injury, and Judge Christine Stetson concurred. In relation to the objective unreasonableness requirement of a pleading prong necessary to overcome the qualified immunity defense, it must be judged from the perspective of a reasonable officer on the scene rather than a 2020 vision of hindsight. Graham versus Connor, 490 U.S. 1989. Plaintiffs have alleged facts and ultimately produced evidence to show that no reasonable government official could have believed that the defendant's misconduct was lawful in light of the information he possessed in clearly established law. See Babb versus Dorman. In the Fifth Circuit, a government official is entitled to qualified immunity unless all reasonable officials would have realized that the challenge conducted was prescribed by law. Cooper versus Morales, Fifth Circuit, 2013. Resolving factual disputes in Gonzalez's favor, the court should accept as true at this stage Gonzalez's allegations that he was ripped out of his private automobile. U.S. versus Fernandez, Mass 2008, I'm sure Massachusetts 2008. Passengers are not required to speak or identify themselves to police unless they witness participating in a crime by the detaining officer. Nobody, I mean, I don't know if I'm sure y'all seen my video if y'all watching this. Nobody's seen nothing but us, me and my wife leaving the parking lot, trying to leave. But and I was struck in the head by Officer McDonald with intent and broke my left arm, causing excruciating pain and discomfort for failure to identify. Regardless, to plead an official capacity claim, plaintiff must satisfy government entitled entity liability requirements under USC 1983, and thus pleaded and proved that the government entity's policies or customs played a part in the violations of federal law. See Monell versus Department of Social Services. And have done so in this action several times. The poly or custom existed in the City of Orange Standard Operation Procedures, page 26, and also Exhibit 1 of my filing, page 37 of 1 of criminal trespass in 5. If a person has never given a prior trespass warning, an officer cannot make a warrantless jail arrest for criminal trespass when the suspect is being held against his will by security guard, business owner, etc. 2, the government policy makers actually are constructively new of existence. Exhibit F1 of my filing, 72 and 73 of the Texas Penal Code, sections 30.05, criminal trespass. A person commits an offense if the person enters or remains on the property of another. 3, a constitutional violation occurred, my Fourth Amendment, to be free from seizures and due process of law. And 4, the custom and or policy asserted is immune force behind the violations. Arrested for resisting arrest. Defendants allege that they were dispatched to a situation where Gonzalez was reasonably believed to be allegedly threatened persons, but posed no immediate safety threat to no one and those around him. Defendants Hill, Cini, and McDonald and Captain Lon Loyce and Lieutenant Lovelace, conspirators, subjects, actors, not the arresting officer Grantham, that contends that Gonzalez was highly intoxicated and considered disorderly by McDonald, Jeannie Cini, and Larissa Hill. The dispatch caller, not 911, and Mr. Gonzalez contends that he did not threaten anyone that evening after being ripped out of my private automobile. The plaintiff complied with a forceful command and told them where he was armed with 2 knives and where they were. He was responsive. 28 U.S. Code 26080 exceptions H, paragraph H, claim any any claim arising out of assault, battery, false imprisonment, false arrest, malice prosecutions, abuse of process, libel, or slander, misrepresentations, deceit, or interference with contract rights, provided that regard of the acts or omissions of this investigations of or law enforcement officers of the United States. The provisions of this chapter and section 1346B of this title shall apply to any arising on or after the date of the enactment of this provision out of assault, battery, false imprisonment, false arrest, abuse of process, or malice prosecutions. Monroe versus Monell versus Department of Social Service of the City of New York. An officer who knows about the unlawful conduct has a realistic opportunity to intervene and prevent harm from occurring as liable. Supervisions must know that the subordinates' misconduct and facilitate, approve, condone, or turn a blind eye toward it. Gendry versus Duckworth, 7th Circuit, 1995. The purpose of this section, investigate a law enforcement officer, means any officer of the United States who is empowered by law to execute searches, to seize evidence, and to make arrests for violations of federal law. Haynes versus Kerner. Allegations which, such as those asserted by petitioners, however inartfully decreed, are sufficient, which we hold to lesser stringent standards that formal pleadings drafted by lawyers. And Woods versus Carey, as claims per and his own persons in a rule in pleading, the pleas to jurisdictions of the court must be pleaded in pro persona. K versus Euler, plaintiff Edward Gonzalez affirms that that there was no crime at issue. He posed no immediate threat to safety of the officers or others. He did not actively resist the Orange City police officers. C. Hanks versus Rogers, 5th Circuit, 2017, stating that significant injuries are no longer required for excessive force claims, and finding that the injury requirement is met because the plaintiff received medical treatment and a diagnosis of noting fracture, acute strains. See 316-page binder that was submitted September 12, 2023 as evidence, along with a thumb drive, electrical stored, and a 316-page binder, Exhibit A, page 4, that I'm submitting with this motion again. Fracture of elbow will put a posterior splint on and a sling, followed with ortho, Michael Kugel. Grantham was given findings likely related to prior injury. At that point, allowed me to go to jail from the medical center of Southeast Texas until the following afternoon at approximately 2:30 p.m., at which time plaintiff's bond was set for resisting arrest and placed bond and discharged. As a result of the assault, plaintiff received a fractured left elbow, torn ligaments, torn rotary cups, and wrist was out of socket, torn back muscles, and other emotional distress, believed to be the point where when McDonald intentionally breaks my left arm, and Officer Grantham watched him do it. And the body camera footage, when you hear me say, "Oh yeah, I like that," is when McDonald intentionally breaks plaintiff's left arm at 7 minutes 13 seconds. When I say thank you for letting it go a little bit, you can hear my bones pop back into place. Wrist, elbow, shoulder. Before the cuffs cause an excruciating pain, and to plaintiff's left arm was swollen. His shoulder on his left side was sore and swollen. His right arm was very badly bruised. All pictures and body camera footage are all on a thumb drive that I provided to the courts and attorneys on case September 12, 2023. And Officer McDonald states that to Mr. Gonzalez that you were involved in disturbance. I stated, no, I was not. And Grantham, standing behind us, whispers, he's right. At .15-minute mark of McDonald's body camera footage under his breath in a whispering tone. And still to date, I have the fractures and other injuries are still present today. With respect to injuries, plaintiff received to his head by being punched, and his arm, being the ligaments ripped off his elbow and tore rotary cups, and other injuries. Plaintiff sought medical treatment, MRI scans at Leopold Vegas Medical Center in Port Arthur, Texas. Since the incident, plaintiff has experienced constant pain and discomfort in the injuries they caused: headaches, wrist and elbow ligaments torn, and torn rotary cups, shoulder discomfort, torn back muscles, neck issues, lower back issues, intentional infliction of emotional distress. There was no criminal violations in the instant case, June 24, 2022. Exhibit U, page 36. After Detective Jinks submitted a DVD on July 21st, 2022, it was refused by the District Attorney, Reese Rose, July 25th, 2022. And I have since submitted a subpoena to the Orange City Police Department, Exhibit U, page 40 and 41, Detective DQ Jinks on January 31st, 2024. Exhibit U, page 42, whereas the undersigned Germer attorney at law is legal counsel for the city of Orange, whereas they state the city nor the Detective Jinks is in possession of the DVD requested. That was February 8, 2024. Significantly, there were no criminal charges ever brought against Gonzalez, such as resisting arrest, despite the deputy's claims that Gonzalez resisted. See Officers Grantham Arrest Report, 45206, Exhibit U, page 24. Resist arrest, N. Page 10, Instant Report, 2211915. Alcohol, N. Drugs, N. And falsified documents of being arrested for disorderly conduct, language 4201, A1. So the arresting officer stated in his report that I did not resist arrest, nor alcohol, nor drugs, so I broke no laws, but subsequently arrested by Grantham for resisting arrest. I don't know what conspiracy is, but I think that's conspiracy. Okay, resisting arrest, conspiracy. Rather, the call for service possible threatened after Jeannie Cini and Larissa Hill conspired and committed theft by deception of property of automobile keys that we had consent by owner for possessions. Exhibit 1 of my filing is Texas Penal Code Title 1, Introduction Provisions, Chapter 1, General Provisions 42 and Section 107, Definitions A in this code. 19. Effective consent includes consent by a person legally authorized to act for the owner. Consent is not effective if A, introduced by force, threat, or fraud. Page 44 is 35. Owner means person who has title to the property, possession of the property, whether lawful or not, or greater right to possession of property than the actor. Or B, is the holder in due course of a negotiable instrument. So what they did, the police department didn't want to go file charges against these two nurses for what they did, and now the judge don't want to hold these two nurses accountable for what they did. So nobody wants to hold nobody accountable. So, and to have OPD reports made it clear from Grantham's official report from the very start that the individual involved was not drunk and disorderly or resisting arrest. It was from a medical event that happened with his friend. My friend punctured his Achilles artery, and I was severe concern for my friend's well-being, as opposed to being engaged in criminal activity. As a result, the need for force was substantially lower than if Gonzalez had been suspected of a major crime. see DeVille versus Marcantel. So these two nurses lied and stole keys from me and my wife, and they kicked us out of their facility. Wouldn't give us our property that was in the vehicle that we asked for. Um, they violated all kinds of laws too. So that's 241 under color 241. I'm sorry. My mind just went blank. Yeah, under color of law, 242 is what the police do, but the 241 is what the other one, 18 USC 241. But qualified immunity, the doctrine of qualified immunity protects government officials from civil damages liability when their actions could have been reasonably believed to be legal. When qualified immunity defense is raised as part of a summary judgment motion, the plaintiff bears a burden of proof of showing that the defendants are not entitled to this defense. To overcome qualified immunity, the plaintiff Gonzalez must show that defendants violate Gonzalez's constitutional right, and the right was clearly established at the time of the challenged conduct. The court has discretion to decide which prong to consider first. United States Supreme Court in Tolan versus Cotton, 2014, states that the first prong asks whether the facts taken in light of the most favorable to the party of certain injuries show the officer's conduct violated a federal right. At the first step, the court should conclude that Gonzalez has alleged facts when viewed in the manner most favorable to him, would establish a violations of plaintiff Gonzalez's Fourth Amendment and Fifth Amendment and 14th Amendment right to be free from excessive force of due process of law. Turning to the second step, the court finds that the constitutional right at issue, the right to be free of excessive force under the Fourth Amendment, was clearly established at the time of the incident, and that accepting Gonzalez's allegations as true, defendants conducted was objectively unreasonable in light of then existing clearly established law. Therefore, plaintiff Gonzalez has met his burden of rebuting defendants' qualified immunity defense. So before and that big old stack of stuff that I've been filing, they said that they had their qualified and they didn't have their qualified. They just wanted me to give up, so I wasn't giving up. So I'm keep on trying to do what I do. To establish a claim of excessive force under the Fourth Amendment, plaintiffs must demonstrate injury, which resulted directly and only from the use of force that was clearly excessive, and the excessiveness of which was clearly unreasonable. DeVille versus Marcantel, 2009, Fifth Circuit. The substance issue to be resolved is whether the lawfulness of a plaintiff's arrest and due process by defendants was established as matter of law. The action for the tort of false imprisonment or false arrest protects the personal interest and freedom from restraints of movement. The restraints may be imposed by the assertion of legal authority, and if an arrest is made without proper legal authority, it is false arrest, and so false imprisonment. And in the context of this case, the essential elements of the plaintiff's claim for relief are an arrest performed by defendants and the unlawfulness of such arrest. With regard to the first element, plaintiff contends that an arrest is clearly shown by evidence that he was in a private parking lot inside of a private automobile as a passenger, leaving with his wife, driver, after being told to leave. Plaintiff was stopped in a non-traffic stop, and the passenger was ripped out of his car and assaulted and handcuffed and demanded identification in case they wanted to do a criminal trespass against plaintiff, and denied my ambulance ride to the hospital per captain. He's not getting away that easy. 22.28 of Captain Longlois's body camera footage. And Lieutenant Lovelace's asking, "Did you get your turkey?" At 16:10, uh, of McDonald's body camera footage, and McDonald said it yes, with intent. That's conspiracy. I don't know what that is, but that's with intent. If Officer Lieutenant Lovelace knew that he did it already, that's with intent. So, did you get your turkey? And McDonald's body camera footage with intent conspiracy, and placed in a squad car by defendant Grantham, who then did not read the Miranda warnings, and no seatbelt attached because my broken arm is cuffed in the back, and by plaintiff's testimony that he felt he was unable to leave the police car. Plaintiff claims that the first element was established by evidence that at no time by law did I have to get out of my car or identify myself. And Exhibit F1 is a Texas Penal Code, page 92, 3802, failure to identify. A person commits an offense if he intentionally refuses to give his name, residence, address, or date of birth to a peace officer who has lawfully arrested the person and requested the information. I was not lawfully arrested. I ambiguously challenged the 3802 failure to identify. B3 requested the information from a person that the peace officer had good cause to believe is a witness to a criminal offense. That one statute in itself violates my Fifth Amendment and 14th A due process of law. I was not outside of my automobile hanging around. I ambiguously challenged Terry versus Ohio. In this case, the officer observed two men standing on the street corner looking through a store window. I ambiguously challenged Pennsylvania versus Mims. I was not in a traffic stop, nor was I driving. Mims was arrested for concealed firearm, and I ambiguously challenged Maryland versus Wilson, 1996. He was arrested for quantity of cocaine. However, the fact that the officers asked the plaintiff to exit the vehicle created a forbidden seizure. Absent to Mims exiting the automobile, the officer would have no grounds for reasonable suspicion, the necessary standard under Terry versus Ohio. So, officers observed us leaving a private parking lot, and I was a passenger leaving with his wife after being told to leave the property. And we told the officers that we were leaving within 4 seconds of the conversations. I broke no laws. No probable cause to arrest in case they wanted to do a criminal trespass against me. Plaintiff claims the second element was established by evidence that at no time any of the citizens of an exceptional emergency center threatened or assaulted by actions of plaintiff. And a statement by Larissa Hill states the officers Grantham conducted a follow-up investigations 2211915 to Exhibit U, page 11, on Saturday, June 25th, 2022, at approximately 21:30 hours, 1321 16th Street, Exceptional Healthcare, to obtain a written statement about the incident that occurred the day prior. He spoke to Larissa Hill, who stated that when Edward had entered the business, he began to use threatening and abusive and vulgar language that caused her to become offended. Larissa also stated that when Edward never made physical contact with her or any other employees, and stated that he never made any specific threats, and mentioned that it seemed he knew what not to say. Larissa also mentioned that Edward would not follow medical staff instructions and made it difficult for them to treat the patient Edward had brought in by holding on to him and being aggressive towards staff. Larissa completed and signed a witness statement that Officer Grantham submitted at the Orange Police Department. The same thing was told by Captain Longlois at 14 minutes 24 seconds, and I want to say he told Larissa to what to say, and Miss Hill and Officer McDonald in his conversations at 17:11. And with her the night prior on his body camera footage that was submitted to the court, and asked McDonald what crime did the plaintiff commit at 9 minutes 50 seconds. Several times, Lone Lois's body camera footage. McDonald could not articulate a crime, resist arrest. As the court has stated several times, it is elementary that the motion for a direct verdict, which is by the nature accepts the view of the entire evidence most favorable to the adverse party and admits the credibility, accepts in extreme cases of the evidence in his favor and all reasonableness interferences to be drawn therefrom, should be granted only in those unequivocal cases where, in the light of evidence as a whole, it would clearly be the duty of the trial court to set aside a contrary verdict as being manifestly against the entire evidence, or where it would be contrary to the law applicable in the case. Henson versus Homeland Insurance. The unlawfulness of the arrest, the first element persists a question. The statutory authority of a peace officer to arrest a person without a warrant is found in Exhibit F1 of my filings. Is the Texas Constitution of Criminal Procedures, page 50, Exhibit F1. Arrest without a warrant, Article 1401, offense within view, which provides in part B, a peace officer may arrest an offender without a warrant for any offense committed in his presence or within his view. 1, for a public offense committed or attempted in his presence, and Title 1, Chapter 14, Article 1403, authority of peace officers, which provides in part, any peace officer may arrest without a warrant persons found in suspicious places and under circumstances which reasonably show that the person had been guilty of some felony. Violations, Title 9, Chapter 42, page 120 of Texas Penal Code. 4201, disorderly conduct, breaches of peace or offense. I ambiguously challenge Texas Penal Code 4201A12, persons who the peace officer has probable cause to believe have committed an assault resulting in bodily injury to another person, and the peace officer has probable cause to believe that there is danger of further bodily injury to that person. Violations of my 4th, 5th, and 14th Amendment. And Smith versus Herbert, in 1958. In our case today, both officers saw me and my wife leaving a private property after being told to leave, and the officer stopped our way of travel and arrested me for resisting arrest. Is typically considered a secondary charge, meaning it is often added up to on top of a primary charge that arises when someone resisting being taken into custody by law enforcement. But in my case, that's what I was arrested for. Exhibit U, page 27, resisting search, and it was 22119115, and it was refused of the charge 30 days after the excessive force and false imprisonment by the District Attorney of Orange County, Reese Rhodes, July 25th, 2022. Exhibit U, page 36, it was held that 2 elements must appear before an offense is committed in the presence of an officer. He must become aware of the acts as a result of his sensory perception, and 2, he must infer that the acts constituted an offense. And elaborating on the second of these elements, the court cited from Garsky versus United States, 1924, for a crime which they have probable cause to believe is being committed in their presence, a duly authorized peace officer may make an arrest without a warrant. The probable cause which will justify arrest for a misdemeanor without a warrant must be judgment based on personal knowledge acquired at the time through the senses. The inference properly to be drawn from the testimony of the senses. The test then for the lawfulness of the plaintiff's arrest is whether it was made with probable cause. The principle of probable cause for arrest was discussed at length by this court in State versus Harris. Probable cause for arrest has been defined to be reasonable grounds of suspicion supported by circumstances sufficiently strong in themselves to warrant a cautioned man in believing the accused to be guilty. Garsket versus United States. As of Texas Penal Code 3803, resisting arrest, search, or transportation. B. It is no defense to prosecution under this section that the arrest or search was unlawful. This is no formula by which to judge the reasonableness of a given case, and each case must be decided on its own facts and circumstances. To require a high degree of technical competencies on the part of the average police officers that expected of the prosecutors would be an unfair and unreasonable standard. The evidence in this case shows that the defendants were personally familiar with the Orange, Texas City Police Standard procedures that I submit to the court as a whole, and in Exhibit F1, page 26, and page 26, page 37-1, in criminal trespass in which it is assumed it had occurred in Orange, Texas at Exceptional Emergency Center, which it entails as in criminal trespass patrol SOP, page 26, 5. If the suspect has never been given prior trespass warning, an officer cannot make a warrantless jail arrest for criminal trespass when the suspect is being held against his will by security guard, business owners, etc. Follow the steps if proved that the subject had received a criminal trespass warning. And F1 is Texas Penal Code Title 7, Offense Against Property, Chapter 30, 3005, Criminal Trespass 9A. A person commits an offense if the person enters or remains on the property of another, had noticed that entry was forbidden, received notice to depart but failed to do so, and failure to identify 3803. A lawfully arrested person. Ambiguously challenged number 3 of 3803, failure to identify, requested the information from a person that the peace officer had good cause to believe is a witness to a criminal offense, violates my 4th Amendment, 5th Amendment, and 14th 1 due process clause on during the proceedings of plaintiff arrest. It was with this background that the defendants arrived at Exceptional Emergency Center and found plaintiff in his automobile leaving the property in the presence of his wife, Michelle Gonzalez, the driver of the automobile. And it was stopped by McDonald's patrol vehicle in a non-traffic stop manner. And Officer McDonald calmly walks to the driver's side and questions us. And then I was ripped out of my private automobile because I failed to identify in case they wanted to do a criminal trespass. Is a violated my 4th Amendment to be secured in the presentment or indictment of a grand jury. 14.1 Due Process Clause, constitutional rights. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. No shall any state deprive any persons of life, liberty, or property without due process of law, nor deny to any persons within its jurisdictions the equal protection of the laws. Under these circumstances, a finding of the defendant had no probable cause to believe that a violation of law had taken place in his presence would be manifestly against the evidence. The trial court magistrate federal judge Christine Stetson did not properly direct the plaintiff. In this case, concludes that the 9 defendants encountered Mr. Gonzalez. Clearly established law demonstrates that the officer violates the 4th Amendment if he abruptly resorts to overwhelming physical force rather than continuing verbal negotiations with the individual who poses no immediate threats or flight risk, who engages in at most passive resistance. Taking the facts as true as alleged by plaintiff, defendants are not entitled to qualified immunity on Gonzalez's 1983 claim. Darden versus City of Fort Worth, Texas, 5th Circuit, 2018. holding that an officer was not entitled to qualified immunity because there were no genuine disputes of material facts as to whether the plaintiff was actively resisting arrest or whether the force used was clearly excessive and clearly unreasonable. So I don't know what clearly excessive and clearly unreasonable stands for, but I think my case pretty much stands for it all. But I ain't got much. I got one more page. The use of force when necessary to make an arrest is a legitimate police function. But if the officers use unreasonable or excessive force, they and their employer are liable for injuries which results. Whether the force used is reasonable depends upon the totality of the facts and circumstances in each case, and factors are considered are 1. The known character of the arrestee, 2. The risk and dangers faced by the officers, 3. The nature of the offense involved, 4. The chance of the arrestee's escape if the particular means are not employed, 5. The existence of alternate methods of arrest, 6. The physical size, strength, and weaponry of the officers compared to the arrestee, and 7. The extragens of the moment. DeVille versus Mercantile, 5th Circuit, 2009. These considerations are sufficiently similar to the grand factors discussed above. Therefore, the court should find that defendants are not entitled to qualified immunity, accepting Mr. Gonzalez's allegations as true, and in the body camera footage to show and resolve doubts in his favor. These will be the issues to be decided by the trial of fact and the jury trial of my peers. Conclusions viewing facts and drawing reasonable interference in plaintiff's favor. The court should find that the defendants are not entitled to judgment as matter of law. On review of a verdict direct for the defendant, evidence will be considered in light most favorable to the plaintiff. United States versus Dunn, 1987. United States versus Hunt, 2001, 5th Circuit. Robert versus Dean, Florida, 1939. Process torts. False imprisonment. The ordinance under which the plaintiff was refused charge was Texas Penal Code 3803, commonly known as resisting arrest or transportation, a secondary charge. B, it is no defense to prosecution under this section that the arrest or search was unlawful. Section 83005, criminal trespass. A person commits an offense if the person enters or remains on or in property of another without effective consent of, and the person, 1, had noticed that entry was forbidden, or 2, received notice to depart but failed to do so. Entry means, entry means intrusions of the entire body. Pro se litigants enter into evidence all laws. State versus Hobbs, the Texas 4th Circuit of Appeals by police on private property to obtain evidence constitutes criminal trespass under Section 3005 Texas Penal Code. I'll put in there Ephesians 6 too at the very bottom. I don't know if y'all can see that. So that's pretty much what I just sent to the court the day before Turkey Day. I filed it November 27th. Like I said, it's 20 pages. I don't know how long I've been on here, an hour. So I'm sorry it took me so long to read all that stuff. But yeah, I appreciate everybody logging in and looking at everything. I don't know if y'all got any questions y'all want to ask, but I mean, I don't know. I'm just trying to get my stuff out there. Understanding that if this happened to anybody else, they can probably just look at my channel and pretty much do what I did. I mean, I try to help as many people as I can. So anyway, I'm gonna go ahead and get off here. I'm in so much pain right now. My back is killing me. I don't show pain. I don't know. Y'all seen it in the video. My arm's still broken. Ain't nothing changed. I did get some pictures. They were all. Oh my God! No. No, I don't have it right here. But anyway, my arm's still fractured, broken, whatever you want to call it. Everything's still the same. Back muscle's still torn. Fighting the whole judicial system. But hoping this Loper Bright Enterprise Chevron deference. What I just done is how you say that word? Ambiguous is challenged. Ambiguous. Yeah, ambiguous. Yeah, AMBIGOUS. Challenge each of the Pennsylvania versus Milne, Texas versus Ohio, and Wilson versus Maryland, and also most of their statutes that they try to use against me. So, the only way that you have to learn the law is to learn the law. But I appreciate y'all coming on. I'm gonna go ahead and get off here. God is great. I hope I didn't offend anybody. But I don't. That's your business. God bless. Hope everybody's doing great. But God is real. Angels are real too. So y'all be safe. God bless. God bless America. God bless humanity, and God bless the world. Jesus coming back. He's coming back quick in a hurry. God bless.